Good afternoon and welcome. Before we begin, if everyone could be sure they're on mute, that would be most helpful, and I think most of you are. Thank you. I'm Sarah Miller Espinosa, and I'm a labor arbitrator and organizational ombuds, a mediator, and most important right now, I'm the moderator of today's session on designing public sector collective bargaining systems. What could be next for Virginia county, city, and school board employers and employees? This is the first of many programs that will be offered by the newly organized Virginia chapter of the Labor and Employment Relations Association. For those of you who are new to LERA, it is an organization that promotes education and understanding of labor and employment relations, and it's our hope that the Virginia chapter of LERA will foster and promote a forum and community where management advocates, HR professionals, union advocates, union leaders, arbitrators, mediators, academics, and all those interested in labor and employment relations can engage in ongoing dialogue, education, and understanding. At the end of today's session, we'll provide you with more information on how you can join the Virginia chapter, as well as information about our next virtual event on May 19th. Before I introduce our panelists for today, Homer LaRue and Clarine Martin, and provide an overview and some context for our discussion, I have a few housekeeping items. So do please stay muted through the program, but you may pose questions or comments through the Zoom chat, and we'll be monitoring those. This session is scheduled for 90 minutes and will end on time at 2:30. The first half of the session will be presentations from our panelists, followed by questions and comments from the audience. Finally, this session is being recorded and will be available on the LERA website for members of the Virginia chapter. So now, without further ado, it's my privilege to introduce Homer LaRue. Professor LaRue is a nationally acclaimed labor arbitrator and mediator who has issued thousands of decisions as a grievance arbitrator, interest arbitrator, and labor relations administrator. He currently serves as the Vice President of the National Academy of Arbitrators. Professor LaRue has been a professor of law at the Howard University School of Law for several decades and founded and co-directs the Howard Law ADR program. Professor LaRue serves as the Montgomery County Labor Relations Administrator for the firefighters' collective bargaining law pursuant to the Montgomery County Code. Professor LaRue earned his bachelor's degree from Purdue University, his law degree from Cornell University, and a master's degree in industrial and labor relations from the Cornell University ILR School. Thank you, Homer. It is also my pleasure to now introduce Clarine Martin. Ms. Martin has served as the Executive Director of the District of Columbia Public Employee Relations Board, PERB, since 2014. In this role, she leads a staff of employees and contracted hearing examiners. Prior to leading DC PERB, Ms. Martin served as the Assistant General Counsel for the University of the District of Columbia, the Associate General Counsel for the Office of the Chief Financial Officer, and worked for the National Labor Relations Board, handling unfair labor practice and representation cases. Ms. Martin earned her bachelor's degree from Howard University and her law degree from Northeastern University School of Law. Now I'll just give you a little bit of context for our program today before I turn it over first to Ms. Martin. The inspiration for our session is that the prohibition against public sector collective bargaining in Virginia has been rescinded. And effective in May, that's next month, individual governing bodies of counties, cities, towns, and local school boards are authorized to adopt local ordinances or resolutions permitting employees to engage in collective bargaining. If a governing body votes to allow collective bargaining, it will also determine the framework and the mechanisms for enforcement of the local collective bargaining option it adopts. And so our discussion today will focus on the elements of the collective bargaining laws adopted by two of Virginia's neighbors, Montgomery County, Maryland, and the District of Columbia, and more specifically, the administration and enforcement of those provisions. Montgomery County is Maryland's largest county with over 1 million residents. Montgomery County government has adopted local collective bargaining laws. In Montgomery County, there are 3 different county code provisions which govern the collective bargaining laws applicable to different bargaining units. There's a provision specific to the police bargaining unit, a separate code provision for the fire bargaining unit, and another separate code provision for the general government workers. Homer LaRue serves as the neutral labor relations administrator who administers and resolves disputes pursuant to the fire collective bargaining code. It's important to note that Montgomery County government adopted these local collective bargaining provisions after being granted the authority to do so by the Maryland legislature. These county codes are not applicable to the public school system, which falls under a Maryland state law applicable to all public schools. The District of Columbia took a different approach. In the district, DC PERB is the neutral and independent agency charged with administration and enforcement of the collective bargaining law. And we are fortunate to have Clarine Martin, the DC PERB Executive Director, to tell us about the district's approach today. And at this point, I'm going to turn it over to Clarine, and I'm going to share my screen.
Can everyone hear me?
Yes.
Hear me? Oh, okay then. Thank you, Sarah, for that fine introduction. I wanted to let everyone know that my presentation will cover a little bit of history of labor relations in the District of Columbia, as well as the powers of the board, and then we will discuss collective bargaining. Prior to the creation of the Public Employee Relations Board, the District of Columbia already had a history of labor relations as early as 1962, when the district was under the federal government and governed by commissioners. Then the district had provisions authorizing limited consultations between the city government and representatives of public employees. Then in 1970, the Board of Labor Relations was created. It appears they did all the things expected of labor relations boards, except for one thing. It could not compel parties to do anything the parties did not want to do. The Board of Labor Relations impact was limited by its lack of independent enforcement powers and the absence of a statutory procedure for court enforcement. With the advent of the home rule to the district, the Public Employee Relations Board was created in 1978. By the passage of the District of Columbia Comprehensive Merit Personnel Act. The CMPA, which is what we call it, was the beginning of the district's personnel policy separate from the federal civil service. PERB is an impartial, quasi-judicial, independent agency empowered with the exclusive jurisdiction to resolve labor management disputes between district government agencies and labor organizations, representing district employees in addition to disputes between employees and the district government and/or labor organizations. While there is oversight by the council and the mayor has powers of appointment, PERB is not an administrative agency under the mayor, and in fact, the mayor's agencies are subject to the PERB's orders in regards to labor relations. May I have the next slide? Here you have let me do something to my screen here. Okay. Here you have a organizational chart of PERB. The board has 5 members, all appointed by the mayor and confirmed by the Council of the District of Columbia. 1 member, the labor member, is selected from those persons whose names appear on a list proposed by labor organizations, each of which has been granted exclusive recognition for at least 250 district employees. 1 member, the management member, is chosen from a list of at least 2 names proposed by an ad hoc committee appointed by the mayor, representing agency heads within the district government. 3 public members, or sometimes referred to as neutral members, are appointed by the mayor. One of the public members is designated as a chairperson of the board. Limitations on the appointment of members, other than possessing integrity and impartiality, are that 1, the experiences of the appointee demonstrate knowledge of the field of labor relations, and 2, a member of the board may not be employed by a labor organization granted exclusive recognition under the district statute. They are appointed for a 3-year term and may serve 3 consecutive terms. In making decisions, PERB draws on its own statute within the CMPA, its own labor law, its own, and from the National Labor Relations Board case law, and also the FLRA case law. Most district employees are in collective bargaining units, and trying to get my screen to move here. In the District of Columbia, there are working condition bargaining units and compensation bargaining units. We have bargaining units of police officers, firefighters, teachers, sanitation workers, university professors, administrative law judges, clericals. Managers and confidential employees as defined in the statute are not included in the bargaining units. There is a statutory definition of what constitutes a supervisor or confidential work, and PERB conducts hearings to look at the job duties rather than the position description of an employee to make its determination. As a rule, as I said, managers are excluded from collective bargaining. However, in the District of Columbia, there are 2 exceptions. The school principals have a union and engage in collective bargaining with the school system. The second exception is that captains in the fire department are in the firefighters bargaining unit. Want to talk about now the powers of the board. Next slide. The PERB has strong administrative and enforcement powers, including determining appropriate compensation and non-compensation bargaining units. PERB is responsible for making sure that employees have a community of interest with the other employees in the unit in which they are placed. Next slide. Another power of the board would be certifying and decertifying labor organizations as exclusive bargaining representatives. PERB is responsible for conducting representation elections, ensuring that the employees are notified, safeguarding that the elections are handled in a fair manner consistent with PERB regulations, and ensuring that the results of the election are accurate. Next slide. Determining whether unfair labor practices have been committed and issuing appropriate remedial orders. Unfair labor practices are prohibited. ULPs, as they're called, include interfering with, restraining, or coercing any employee in the rights to either join or not join a union, violating the duty of fair representation, refusing to bargain in good faith with the exclusive representative, or in the case of the union, refusing to bargain in good faith with management. Failure to provide information is another. Next slide. The board also resolves bargaining impasses through fact-finding, final and binding arbitration, and other methods agreed upon by the parties as approved by the board, and to remand disputes if it believes further negotiations are desirable. This will be discussed later on when I talk about collective bargaining. Next slide. Determining whether a particular subject or proposal is within the scope of collective bargaining. While negotiations are in progress, a party may present a negotiability appeal for board determination when a proposal is rejected by the opposing party as non-negotiable. The board makes a determination as to whether the proposed subject is mandatory or is permissive or is prohibited by statute. If the proposal is mandatory subject, the proposal is negotiable and sent back to the parties to continue negotiating on that proposal. Next slide. The board also considers appeals of grievance arbitration awards pursuant to grievance procedures, provided that such awards may be modified or set aside or remanded in whole or in part only if the arbitrator was without, this is very important, Only if the arbitrator was without or exceeded his or her jurisdiction, the award on its face is contrary to law and public policy, or was procured by fraud, collusion, or other similar and unlawful means. When a party disagrees with an arbitration award, it may seek board review by filing an arbitration review request. This is not a review of the merits of the case, however. Next slide. The board has the power to investigate standards of conduct complaints brought against unions, and unions must be free from corrupt influence, and influence is opposed to basic democratic principles. For example, in those cases where the union elections are not held pursuant to bylaws, or the union funds are not accounted for, union members may file a standard of conduct complaint to the board, where the board would conduct an investigation, a hearing into the allegations. If the violations are found, the board may enter a cease and desist order, or in the case of elections, order a union to hold internal elections enforceable in court. Next slide, please. The board's power also is to conduct investigations, issue subpoenas, hear testimony, and take evidence under oath at hearings on any matter subject to its jurisdiction. The board conducts fact-finding hearings in unfair labor practice cases, standards of conduct cases, and some representation cases. These hearings are conducted by hearing examiners contracted by PERB. The hearing examiner writes and submits a report and with recommendations to the board that the staff reviews and refers to in drafting a board decision and order. Next slide. The board has the power to seek appropriate judicial process to enforce its order, otherwise carry out its authority. The board has the authority to seek enforcement of its orders against non-compliant parties. Generally, the prevailing party files a petition for enforcement. Following an informal discussion with the parties to verify non-compliance, the board will issue an order granting the petition. PERB then moves forward with enforcement proceedings in the Superior Court. Next slide, please. Develop a system for collection, maintenance, and dissemination of labor management relations information as appropriate to the needs of the district, labor organizations, and the public. PERB has all its decisions on its website that can be sorted by name, case number, or subject matter. All board cases are published in the DC Register within 60 days of the board's decision. On the second Tuesdays of the month, PERB conducts a 2-hour training session on labor relations attended by both managers and union representatives. The sessions are called Second Tuesdays at PERB and is conducted by a John Higgins, a retired from the National Labor Relations Board, currently teaching at Catholic University School of Law, and the editor-in-chief of the 2-volume treatise Developing Labor Law. If interested, you may find information on our upcoming session on our website at www.perb.dc.gov. This last slide this next slide shows case handling process of PERB. As you can see, some cases are decided on the pleadings. Those are the cases that have undisputed facts. PERB tries to mediate cases with disputed facts before sending to a hearing. All cases not settled or withdrawn are sent to staff for a decision and order to be drafted, and then is sent to the board for a decision. My next segment of my discussion is collective bargaining. And you can just hold that frame right there. As indicated previously, the district allows the unions to bargain over wages as well as working conditions. The board gets involved in contract negotiations when the parties are in dispute about the negotiability of proposals or the failure or refusal to bargain in good faith. The board applies the U.S. Supreme Court standard concerning subjects for bargaining established in National Labor Relations Board versus Bogg-Wagner. The citation is 356 U.S. 342, 1975 case. The three categories of bargaining established in that Supreme Court case are mandatory subjects over which the parties must bargain, permissive subjects over which the parties may bargain, and then there are the illegal subjects over which the parties may not legally bargain at all. As for mandatory subjects of bargaining, the labor relations section of the CMPA provides that all matters are negotiable, except those that are proscribed by the labor statute. The board has held that this language creates a presumption of negotiability. Next slide, please. What you have before you is management rights clause that is actually in our statute. As for permissible subjects of bargaining, the district statute has a management rights clause that grants management the sole right to direct employees to hire, promote, transfer, assign, suspend, demote, terminate, to determine the budget of its organization, to determine the number of employees, technology, or security. Management is not required to discuss these topics in contract negotiations. However, negotiations on these topics are permissible, and management can waive its right to negotiate these subjects. If management decides to waive its right to negotiate these subjects, it is only for the duration of the collective bargaining agreement. During a term of a contract, if management changes a non-negotiability working condition, management must engage in impacts and effects bargaining to avoid an unfair labor practice violation. I don't have a slide for prohibited subjects of bargaining, but prohibited subjects of bargaining are issues identified in the statute and would include the prohibition against strikes and the prohibition against negotiating reduction in force. They are not subjects of bargaining. With the specific regard to RIFs, though prohibited, management must engage in impact and effects bargaining to avoid an unfair labor practice violation. In the District of Columbia, we have compensation negotiations and non-compensation working condition negotiations and agreements. Slide 17. Non-compensation negotiations. When parties are unable to agree on working conditions, one or both parties may file a notice of impasse with PERB. The executive director initiates an informal inquiry to determine whether the parties are at an impasse. If it is determined that the parties are at impasse, the parties may decide to engage in impasse resolution procedures, including mediation, fact-finding, arbitration, or any combination of those. If the parties cannot decide, then it's the executive director who will send them to the mediation. And if that is unsuccessful, they can be sent to arbitration. The arbitrated agreement is then sent by the parties to the District of Columbia Council for information purposes only. Next slide. Compensation negotiations. When parties are unable to agree on compensation, one or both parties may file a notice of impasse with PERB. The executive director of PERB conducts an informal review and determines whether the parties are at impasse. If it is determined that they are not at impasse, they are sent back to negotiation tables. If it is determined they are at impasse, the parties are sent to mediation, and if unsuccessful, to arbitration. The arbitration award is sent by the parties to the Council of the District of Columbia for approval. And that concludes my presentation. And I will turn this over to Professor LaRue.
Thank you so much, Clarine. Homer?
All right. Thank you very much, Clarine, and thank you, Sarah. What I want to do is to compare and contrast the Montgomery County Code, which I call an ordinance or the mini PERB model. And what you'll see is that there are some differences and there are some similarities between the Montgomery County Code and the DC Code. Next slide, please. The areas that I'm going to talk about are jurisdiction of the laws and those codes. Talk about the labor relations administrator and its his or her powers. What are subjects of bargaining, impasse procedures, and prohibited practices. Next slide, please. As Sarah indicated, there are three different bargaining units covered by three different codes or collective bargaining laws. All of them are found in Chapter 3 of the Montgomery County Code. Next slide, please. The first one covers, as Sarah indicated, covers what I'll call non-uniformed employees. Article 10 covers firefighters. And you'll notice that captains are included in the bargaining unit. It's a little bit, these are the general categories that are discussed in the code. There are a couple of others, but for the sake of brevity, I didn't include all the categories of captains. But that's one thing you might note as distinct from what Clarine said about the collective bargaining law in the District of Columbia. Next slide, please. And then the final is the police labor relations law. Now, one of the things to note about all three of these codes is that they cover different employee classifications, but the essence or the substance of these codes are all essentially the same. So that we're talking about the same principles being applied, irrespective of whether we're talking about police, fire, or the general employees. So next slide, please. What are some of those policies that we find? Well, first of all of the codes are intended to promote a harmonious, peaceful, cooperative relationship between the county and county government and its employees. All three of the codes recognize the right of employees to bargain collectively or to refrain from doing so, a similarity with the law in the District of Columbia. It also permits the employees to choose their own bargaining representative. Next slide, please. And the bargaining representative, and I think this is very important for those who will be, as in Virginia, will be new to the bargaining process. The bargaining representative is the exclusive representative of those in the bargaining unit on matters pertaining to wages, hours, and working conditions. Next point, please. But this is the point I think I want to emphasize here. Obviously, before collective bargaining comes in, cities, counties, municipalities had ways of dealing with wages, hours, and working conditions. Once a collective bargaining representative is chosen by the employees, these may not be used in addition to what is negotiated in the collective bargaining agreement. Rather, the collective bargaining agreement becomes the exclusive means by which the disputes between the employees and the employer may be resolved. Next slide, please. Let me move on now to the Labor Relations Administrator. And I'm going to talk about the powers of the administrator, the qualifications to be an LRA, and the appointment process. And here, I think you want to note some of the distinctions between PERB and the Labor Relations Administrator. And to some extent, this is where the essence of the mini PERB, as I've called the LRA process, to be found. Next slide, please. So first of all, there is one LRA, one Labor Relations Administrator, appointed under each one of the bargaining codes. So that means that there are 3 LRAs in Montgomery County. The LRA is empowered to administer the code, and there's more language that explains what that means. The LRA also resolves disputes between when a dispute arises with regard to the selection of the bargaining unit. to resolve disputes with regard to certification and decertification, and has the power to resolve prohibited practice charges, about which all of three of these I'll talk a little bit more about in detail. And then finally, the LRA is empowered to hold hearings, administer oaths, examine witnesses and documents, take testimony and evidence, and issue subpoenas for witnesses and documents. Nothing very different here from what you saw in terms of what Clarine was talking about with regard to the PERB board. Next slide, please. The appointment qualifications of the LRA. The code requires that the LRA be an experienced neutral in labor relations and not be in any role that could be characterized as representing either an employee organization or an employer. Those are the two primary qualifications. Next slide, please. In terms of the appointment, the LRA under each one of the codes is appointed by the county executive. And that appointment by the county executive is subject to confirmation by the county council. The LRA is selected from a slate of 5 nominees, and those nominees are agreed upon by the county's chief administrative officer and the union representing the particular bargaining unit for which the LRA is going to be appointed. Next slide, please. Each LRA is appointed for a 5-year term, and it's subject to an additional 5-year appointment with confirmation by the council. The fees and expenses of the LRA are paid for pursuant to a contract between the LRA and the county. But keep in mind that the LRA is not an agency of the county. It is an independent organization, a neutral organization, just as Clarine described the PERB in the District of Columbia. Next slide, please. Let me now talk about subjects of bargaining. And here I think you're going to see a lot of similarity between the codes on the one hand and what Clarine was talking about with regard to the District of Columbia. First of all, next slide, please. What do we mean by collective bargaining? Obviously, those of us who have been around for 30 plus years, not me, I'm too young, know the meaning, but it doesn't hurt us to remind ourselves. It means that the parties must meet at reasonable times and places, and they must negotiate in good faith on appropriate subjects of bargaining, some of which Clarine has already laid out. Now, what it does not mean is important as well. It does not, the code does not compel either party to agree to a proposal or to make a concession during bargaining. Next slide, please. Some examples of mandatory subjects of bargaining are laid out in the codes, in all 3 codes. They include salaries and wages, pension and other retirement benefits for active employees, not for retirees, for active employees. Obviously, it covers hours and working conditions. Grievance and arbitration procedures are mandatory subjects of bargaining. And matters affecting employees' health and safety are also mandatory subjects of bargaining. And then finally is what Clarine called impact and effects bargaining. Impact bargaining is required where there's been an exercise of a management right. The union cannot challenge that. But if it causes a loss of existing jobs in a unit, the union can demand bargaining about that impact on the bargaining unit. Next slide, please. In terms of subjects of bargaining, the codes, all 3 of the codes also outline or identify rather in detail management rights and non-mandatory subjects of bargaining. The principle here is that whatever is bargained must not impair or impede the right of the employer to first determine the budget and mission of the employer or any agency of the county, must maintain and improve if it may not impede the county's ability to maintain and improve the efficiency and the effectiveness of operations. It must not impede the county's power to determine the services that are to be rendered, or to determine the structure. Next point, please. The methods, the processes, or means, job classifications, or the location of facilities. All of these are within within management's rights. Obviously, management has the right to direct and supervise employees. And then finally, in all of the codes, management has the right to hire, discipline, fire employees for cause subject to a grievance procedure in the CBA. Now, if you want to see a full list of those management rights and non-mandatory subjects, Chapter 33, 5, 7, and 10 lay them out in great detail. I didn't see the need to go through all of them in this presentation. Thus, the code lists several others that you will want to take a look at. Let me now move to impasse procedures, because I think that that's something rather unique in the Montgomery County Code in terms of collective bargaining, although there are similarities with the District of Columbia as well. And here, I'm going to talk about the procedures that are involved, the role of the county executive, and the role of the county council. Both of those have independent roles in the impasse procedures. So let's look through the impasse procedures first. The code provides a date for the start of bargaining and the conclusion of bargaining and any bargaining impasse. So there's a date certain when bargaining must begin and when the impasse must end. And obviously, this is all tied to the consideration of the annual budget. These matters must be concluded so that it can be included in the annual budget of the county. The collective bargaining agreement is effective only after ratification by both parties. The codes also provide a date certain when the code and before the bargaining begins, when the parties must select an impasse neutral. Now, let me just pause here for a moment and give you an example of what we're talking about when we talk about an impasse neutral in this context. We're talking about a person that the parties agree will be the mediator in case there's an impasse. And if the unresolved matters are not resolved in mediation, that same person will be the arbitrator, the interest arbitrator as well. And you'll see more when I talk about that later. So I have served, for example, as the impasse neutral, the mediator / arbitrator for the non-uniformed employees in Montgomery County for the last 10 years. It's also the length of time in which I have been the labor relations administrator under the collective bargaining law for firefighters. And there are 3 other people who have served those roles as well. Now, if there is no collective bargaining agreement by a date certain that is set in the codes, then there is an impasse by operation of law. And then upon that impasse, the parties have an obligation to submit the dispute to the impasse neutral. And the impasse neutral then attempts mediation of the impasse. Next slide, please. The impasse neutral, upon finding there to be a bona fide impasse, then requires the parties to submit all items that have been negotiated and agreed to the impasse neutral. Also, the parties are required to submit a final offer consisting of all proposals not agreed upon, meaning come up with your final offer with regard to the matters about which you haven't agreed and set those down in writing. Those get submitted to the impasse neutral. Now, that's an important point in the impasse procedure, because after submission to the impasse neutral, neither party may then change their final offer. What they can do is negotiate a resolution of anything that was included in the final offer. And at that point, then they may withdraw that item from the final offer. But no other changes by either party of their final offer is permitted once the matter goes to the impasse neutral. Next slide, please. The impasse neutral then may require a hearing in order for the parties to submit evidence and arguments on their final offers. This is significant as well. Those hearings are not open to the public. And I think that's been an important point between the parties. By a date certain in the code, the impasse neutral must select the final offer that as a whole, the impasse neutral judges to be the more reasonable offer. So it's final offer, arbitration. The impasse neutral hears the arguments of the parties on their respective final offers and selects the one that the impasse neutral believes is the most reasonable. The code also now sets forth, and this is important as well as you begin to think about developing your collective bargaining ordinances in the state of Virginia. The code sets forth the factors that the impasse neutral must consider in selecting one of the two final proposals. And I just want to give you a flavor of what some of those considerations are that are set forth in the code. Next slide, please. So this code sets out, it's 8, not 9. Sorry for the error there. There are 8 criteria for deciding on which offer is more reasonable. And the highest consideration is ability of the county to pay under all 3 of the collective bargaining agreements. And what that means is the ability to pay considerations are looking at short-term and long-term expenditures. And short-term and long-term expenditures that and what limits there are on the county's ability to raise taxes under state law. I don't know what those would be in Virginia, but in Maryland, there are certain limitations. It also speaks to the impasse neutral considering as part of the ability to pay the burden on taxpayers, if any, resulting from those increases in revenues needed to fund that final offer. And then finally, the ability to continue to provide the current standard of all public services. So what you see here is that the codes provide the impasse neutral with a criteria that the impasse neutral is to apply in determining which of the two final offers is the more reasonable. Next slide, please. Now, after considering the ability to pay, the impasse neutral may then consider 5 other criteria for reasonableness. They are interest and welfare of the county's taxpayers and service recipients, past bargaining history that led to each of the agreements, wages, hours, benefits, and conditions of employment of similar employees of other public employers in the DMV, in the District, Maryland, and Virginia area. Wages, hours, benefits, and conditions of employment of other county employees. And then finally, consideration of wages, benefits, and hours of other working conditions of private employers in the county. Next slide, please. The selection of the most reasonable offer has to be based on 1, the content of the offer integrated with the previously agreed upon terms. So the impasse neutral is looking at the whole package. The impasse neutral may not consider offers of settlement not contained in the offer submitted to the impasse neutral. So whatever the parties talked about, if it doesn't end up in their final offer, it's prohibited for the impasse neutral to consider that. The impasse neutral must not consider any other information concerning the bargaining leading to that impasse. And then finally, the impasse neutral may not compromise no alter the final offer that is selected. This is final offer arbitration. That means you take the whole package of one, you can't change it, can't compromise it. You have to make a decision which one is the more reasonable. And then finally, next slide, please. The final offer, including those items that had been previously agreed upon, is the final agreement of the parties. Now, what does that mean? It means no ratification is required by the parties. The decision of the impasse neutral becomes the agreement between the parties. The final agreement then has the force and effect of an agreement that had been voluntarily entered into and ratified by the parties, which if they had not gone to impasse, they would have done. The parties then must execute that agreement that is selected by the impasse neutral. They do not have an alternative. Now, let me move to, we have the agreement now. Let's talk about what the county executive's role is. The county executive must describe that agreement, the collective bargaining agreement, in the proposed annual operating budget and include any changes from the prior collective bargaining agreement. Must also include an estimate of the cost of implementing the collective bargaining agreement as it's been constituted by the impasse neutral. And then finally, include sufficient funds in the proposed annual operating budget to fund the CBA. This last point a few years back was a major point of contention between all of the unions in Montgomery County and the county. Next slide, please. The county executive also must define all the terms in the CBA that may require an appropriation of funds, that may be inconsistent rather, with county law or regulation, or that may require the enactment or adoption of any county law or regulation, or which has or may have a present or future fiscal impact on the county. All these things must be described by the county executive. So let's assume the county executive has fulfilled the executive's function. We now turn to the county council and its actions. The council may hold a public hearing and permit the parties to the agreement, as well as any member of the public to testify about the collective bargaining agreement. The council may accept or reject all or part of any term or condition in the agreement, which, and this is the criteria for rejection, requires an appropriation of funds that may be inconsistent with any county law or regulation, that requires the enactment or adoption of any county law or regulation, or which has or may have a present or future impact. Now, what we're seeing here now is that the council, even if the chief executive submits it to in the annual budget, the county council retains the purse, the keys to the purse. And if the council is intending to reject all or part of the agreement, it must do so by resolution of the council. Next slide, please. If the council does intend to reject, notice intend to reject. So this is taking place before the council has actually rejected it, but in effect, the parties know that that would be the effect if they didn't renegotiate. And so what happens next is the council selects a representative to present the council's position as to its reason for intending to reject, and that is presented to the parties. That triggers the obligation of the parties to enter into further negotiations on the matters intended to be rejected by the council. Next slide, please. Then if the council indicates an intent to reject, it must then, well, First of all, that means then that the impasse procedures kick in and the council representative participates in the renegotiation and impasse process that I described earlier. The results of the parties' bargaining is then submitted to the council as a renegotiated agreement by the parties, and the council acts on the renegotiated agreement. Now, conceivably or theoretically, the same thing could happen again. The council could say, this is still not acceptable, and we intend to reject it, and the process would start all over again. More likely, however, there's been a lot of talk back and forth, and the renegotiated agreement has been indicated to the parties by representatives of the council that they're prepared to accept that. Otherwise, they just practically they wouldn't go back and submit something that they had some hesitancy about whether the council would approve. The final area, and then I'll close up and we can have take on questions of prohibited practices. I'm not going to go very much into this because what Clarine said about prohibited practices or said about unfair labor practices, under the codes, they're called prohibited practices. Under the National Labor Relations Act, they would be called improper practices. They're all the same. And next slide, please. The code provides for prohibited practice charges to be brought by the employer, by the union, or by an individual employee. And the various prohibited practices are laid out in all the codes. The point I want to end with is the final one. Next one, please. Under the codes, there's a strong deferral policy under the codes. And what I mean by that is, let's assume the union brings a prohibited practice. When the LRA considers what the terms of the prohibited practice are, what the LRA determines is that it's really a contract violation. It may also be a code violation. What the code does, it says that the LRA must defer the party's grievance procedure. Next bullet point, please. If the employer and the union have negotiated a valid grievance procedure, and there is one in all three of the bargaining units to which I'm referring. And then finally, if deferral to that grievance procedure would not result in the application of principles repugnant to the code. So one of the things that I have had reason to, I've had prohibited practices brought before me as the LRA and deferred them because I think this is very strong language that says that's the preferred way to have even prohibited practices resolved, i.e. through the grievance procedure. Finally, next slide, please. All the codes provide for no lockout by the employer and no strike by the union. And the final slide is simply gives you the citation if you're interested for the Montgomery County laws. Next final slide, and I want to thank you, and we can take questions. However, Sarah wants to proceed now.
Thank you very much. And I am just looking for the chat box so that we can start pulling the questions. Here we go. So the first question is that I'm going to ask, and Homer, I think this question is directed to you and your presentation. Can you speak more about how the ability to pay is determined under the Montgomery County Code?
Under the codes, as I pointed out, there are the primary consideration or the first consideration that the impasse neutral must give are those criteria that I laid out as classified under the ability to pay. Does the county have the ability under state law to raise taxes? What would be the effect on the county's services? Were raised to to fund the collective bargaining agreement. Those are considerations of ability to pay. Those were the things that went into discussions when the code was first drafted, and the impasse neutral is required to consider those and in the order in which I mentioned it. So the impasse neutral could not look at other public employees and what they were paid before the impasse neutral completed the consideration of ability to pay.
Okay, thank you. And the next question is first for you, Homer. Professor LaRue, if you're willing to say, what would you change about the Montgomery County Ordinance?
Well, so far we've been lucky that we haven't had a slew of cases. I think that one of the things that I think that in the near future, there may need to be a little bit more structure to the code. If we had the caseload that Clarine has in the district, one person couldn't do it. By and large, however, I believe that the impasse procedure has worked effectively over the years. I think the grievance arbitration process has worked effectively, that the parties have been able to mature in their relationship and resolve the matters that have come before them in a way that hasn't disrupted the service in the county and has met the goal of a harmonious and cooperative relationship between the parties.
Thank you. And Clarine, is there anything about the CPMA that you would change, if you'll say? Oh, you're on mute.
Okay. I really do believe that our system is very effective, and I don't think there's anything that I would change.
Okay. And Clarine, next question first to you. Do the negotiated grievance procedures included in the collective bargaining agreements in the district include binding grievance arbitration as the last step of the process?
I'm sorry, repeat that?
Mm-hmm. In the collective bargaining agreements in the district, do you have binding grievance arbitration?
Binding grievance arbitration. Well, PERB does not get involved with the contracts. We don't negotiate contracts. That's left to the another agent for the city. It's left to the Office of Labor Relations and Collective Bargaining. And but the binding arbitration, yes, binding arbitration would be in their collective bargaining agreements. They're binding arbitration agreements.
And if I can add,
yes,
just a footnote to that, having served as an arbitrator in the District of Columbia for police, fire, and not the school, but others, in every one of those, there's a binding arbitration.
Yeah. And Clarine, could you remind us again, PERB's role when a party challenges an arbitration award, a grievance arbitration award?
Well, the party who is challenging it would file a petition with the PERB, and then PERB would, excuse me, PERB would review what the parties had presented, and then make a decision as to whether or not the arbitration was within the jurisdiction, or the decision was within the jurisdiction of the arbitrator, whether or not the decision was rendered was free of fraud. And I think there's another one as well, but there's a limited role for PERB with regard to arbitration reviews.
Thank you. And Homer, is there any role for the LRA for arbitration reviews in Montgomery County?
There is not. As I read the codes, I think the resort of the party who thinks that the arbitrator went astray is to go to court. There's nothing in the code that I would say gives me as the LRA authority to do what Clarine does under the PERB.
All right, thank you. And next question. And so we'll have Clarine first and then Homer. In DC and in Montgomery County, how long did it take to obtain local collective bargaining? And then there's a comment here. I do know that in Texas, it's taken more than 20 years to obtain collective bargaining in Harris County, where there is a local option. So Clarine, how long did it take the district?
Well, the district has been dealing with, labor relations since 1962. However, the collective bargaining itself, entering into agreements, I think in my presentation, I think it was 1970 that the Board of Labor Relations was given the authority to recognize unions. But labor relations has been going on for quite a while in DC, since 1962.
Thank you. Homer?
Yeah.
Well, Sarah, I think you answered this in your introduction when you said that the codes came into being in Montgomery County in 1975, I believe. I wasn't here then, hadn't had an occasion to go back that far, but sometime before that, obviously there was a period in which there wasn't negotiations, but I don't know, maybe you know, Sarah, what how long it took for up to 1975.
Yeah. So I don't know what happened before the 70s in Montgomery County, but I do think it's interesting to note that in Maryland and in Montgomery County, the legislature did, and we mentioned this in the introduction, did have to grant the authority to Montgomery County to actually pass its own collective bargaining ordinance. And so once that happened, there was a series of council actions and some charter amendments, actually,
Right.
that were voted on in the county in order to not only establish the different bargaining units, and of course the police came first, so their code provision was first, and then fire and the general government workers. And then I believe there was an additional charter amendment to actually grant the general government workers interest arbitration.
Right. I do recall that as well. And
Let me also add that we had Congress did allow negotiations initially with police and firefighters, and then the DC public schools were in consultation with teachers prior to 1970, the 1970s.
Good. Thank you. All right. The new law in Virginia doesn't establish a labor board or provide very much guidance at all to local jurisdictions who are looking to adopt a local option for collective bargaining. And so what advice would each of you offer to the counties or school boards who are looking at doing this?
Well, one of the things I would suggest is one size won't fit all. And so what works in Richmond, for example, might not work in one of the smaller counties. And what we do in one of the smaller rural counties might not be appropriate for Richmond. So consider the size of the workforce that is being affected. And it may very well be that in the larger municipalities in Virginia, you will need something more than a labor relations administrator. And in others, perhaps that would work. I think Montgomery County has been fortunate in that there's been pretty good labor relations, mature labor relations. And so the LRA process has worked. And I can see that if it became highly contentious, it might be a bit more problematic.
Thank you. Clarine, any advice for the Virginia jurisdictions?
Whatever Virginia comes up with, I definitely recommend highly that they have enforcement powers and allowing them also to enforce their orders through the court system. Otherwise, it's a waste of time.
In addition, to what Clarine has just said. I completely agree with her. I think now is the time to begin to think about setting this up. If the county, particular governmental entity waits until they have a union that says we've got a majority of cards of people who want to be represented, and you then start to set up a structure, you may be running behind the 8 ball. So it's something that I think is useful to begin to think about earlier rather than later.
Thank you. I think that we've run through most of our questions, so I'm going to encourage you all, if you have any other questions, to type them here into the chat. And while I'm giving you a moment to do that, I'm also going to remind you about the Virginia LERA Chapter, and that you are able to join the Virginia LERA Chapter for only $50 for the entire year, which is a pretty good deal. And chapter membership will include access to these recordings of the various sessions, as well as the PowerPoint presentations that are and other materials that are made available by our speakers. And so I'm sure we'll be including in our chat a link to the chapter membership. All right, we have another question coming in. Okay, Cheryl, I think there may be
There's a typo. It should
a
be
typo. The PRO Act. Any concerns about how the PRO Act may directly impact the PERB or the LRA?
I hadn't really given that any consideration. Could you tell us a little bit more what what the questioner thinks about the intersection of the LRA and the PERB with the PRO Act?
Cheryl, can you take yourself off mute?
Okay, good afternoon. The question particularly concerns the issue of electronic voting for union membership. There are other things contained in the PRO Act, but that's really what my question pertains to. They will allow electronic and remote voting to adapt representation by a union and permit less interference by managers. So I was just wondering if there was any thought about how this might impact PERB or LRA, if at all. Thank you.
My sense is that because the subject is alive, generally in our discourse, it may have an impact in that way. But I'd be interested in hearing what Clarine says about this as well. But labor relations has been establishing means of voting in elections for some number of years. And I would imagine that any experienced labor relations person is going to draw from that precedent, not from our political shenanigans, if you will, over the last few months.
Clarine, thank you, Homer. Can you tell us?
Yeah. No, I don't have any particular view whatsoever on that one.
Okay, and Clarine, could I ask you a sort of a related question about how elections are conducted in the district? Are those conducted on site? Are they by mail?
It's up to the union. What we do is most of our elections are conducted on site. However, if a union requests that an election be conducted by mail, then we will accommodate them. Recently, we have, because of the pandemic, we have conducted 2 elections by mail, and imploring the third-party contractor to conduct those elections. And they've gone very smoothly, and both union and management have been pleased with the outcome of the process, I should say.
Thank you. All right, I'm going to ask our panelists if they have any last thoughts to offer to those considering the possibility of these local collective bargaining ordinances and resolutions in Virginia?
One thing that I would say is that I'm old enough to remember when public sector collective bargaining was getting started. I was still a graduate student at Cornell when it was happening. It was a very exciting time. And I think that one of the things that I found most interesting about it, and I guess I would admonish Virginia to really think about this, is to begin to have these kinds of discussions and really look for best practices. We now have 2 or 3 decades of public sector collective bargaining. We were creating that back then with very few models. I would suggest that take a look at the various models around the country, not just Maryland, but New York, for example, other places, and find out, make a conscious effort to determine what would work best in this county or this city. There's a lot to draw from.
Thank you. Clarine?
I would begin to prepare my managers for collective bargaining and for how they're to treat employees. I would start educational projects for them. I teach them about unfair labor practices and wine garden rights and what the rights are of the employee. And I think that's very important for everybody to have some educational background on labor relations, so that, because I do believe, and let them know also, it's very important. Many people think that having a union and managers, there has to be some dissension between the two. And that is not the case. There is no reason why the parties cannot have an amicable relationship with each other. And that's one of the things that Virginia can start off with its managers, telling them, there's this, you can use the union to assist you in managing your employees. And having, basically it's all about, and so that's what I would start, an educational program for managers. And where you have unions or employees, have an educational program for that. That has been very helpful for PERB in terms of we had a lot of dissension between certain unions and managers, and we started having these educational programs, and we don't have as many cases being filed now because people understand what their rights are. And if people understand what their rights are, there's no reason to have dissension between each other, as well as file unfair labor practices. Education is the key.
Thank you.
I would agree.
Well, that is excellent advice. And I can't thank both of you enough for these incredibly thorough and thought-provoking presentations that you've made. And I think it's a real public service that you have both done for Virginia. And I thank you very, very much for your time and your wisdom.
Thank you. And
Thank
good
you.
luck. Good luck, Virginia.
Thank you. And so everyone, thank you all for joining us for the first event for the Virginia LERA chapter. Again, I'm going to encourage you all to join the chapter and also to register for the next event, which will be on May 19th at 1 o'clock. And again, this is actually where we're going to continue this conversation and be having a discussion about those labor management relationships and the different choices that the parties can make and the different approaches that they can take and how that can impact collective bargaining. And we'll be doing that with 2 directors from the Scheiman Institute on Conflict Resolution at Cornell University, Sally Klingel and Ellen Gallen-Presida. So thank you all very much, and I'll look forward to seeing you all on May 19th. If you've got any questions or other concerns about or any information you'd like from the Virginia chapter, there's information on the Virginia chapter website, and you'll be able to reach out and we'll get you answers. Thank you.
Thank you very much, Sarah.